The law can be fascinating. We're going to begin this Layman's Law channel with a little case that dates from 1722 out of England. It regards the old saying in American usage, finders keepers, losers weepers. Well, as this case will show, the first part of that is correct, finders keepers. But the second part, losers weepers, is not a statement of the law as it now stands, or as it has always been under common law. Let me just read this very short case to you, and then we'll discuss it a little bit following that. The plaintiff, being a chimney sweep's boy, found a jewel and carried it to the defendant's shop, who was a goldsmith, to know what it was, and delivered it into the hands of the apprentice, who, under pretense of weighing it, took out the stones, and calling to the master to let him know it came to 3 halfpence, the master offered the boy the money, who refused to take it, and insisted to have the thing again. Whereupon the apprentice delivered him back the socket without the stones. And now in trover against the master, these points were ruled. I will just step in for a moment here to say that trover was an old English method of filing a lawsuit, and we'll probably do a video on some of those old terms pretty soon, because they too are fascinating. It comes from the old French, to find. In modern French, it would be trouver, and in the old French it was trouver or something like that. And the English adopted that term. Number one, that the finder of a jewel, though he does not by such finding acquire an absolute property or ownership, yet he has such a property as will enable him to keep it against all but the rightful owner, and consequently may maintain trover. 2, that the action well lay against the master who gives a credit to his apprentice and is answerable for his neglect. 3, as to the value of the jewel, several of the trade were examined to prove what a jewel of the finest water that would fit the socket would be worth, and the Chief Justice directed the jury that unless the defendant did produce the jewel and show it not to be of the finest water, they should presume the strongest against him and make the value of the best jewels the measure of their damage, which they accordingly did. So they found for the finder, the young chimney sweep's boy who had found this jewel. Now, let's talk about this just a little bit. Number one, the major point of law here is that if you find something, it's yours. You have a title to that by virtue of having found it. And your title is better than anybody else's title in the whole world, except for the true owner. So let me give you an example. I lost a class ring while I was visiting some relatives in Florida. And a year and a half later, when I was a student in Switzerland, my class ring showed up in the mail. A young, mentally challenged neighbor had found my class ring in the sand by a lake and had showed it to his parents. Well, he could have claimed title to that class ring except for my title. And being the kind of people that they were able to see where the ring was from, Brogdon High School in North Carolina, and it had my initials on the inside, so they were able to identify me. And they then recognized that it was probably my kinfolk who were neighbors of theirs who would know more about the ring. So they took it to them, showed it to them. Long story short, it showed up in the mail at my place in North Carolina while I was in Switzerland. And that was well over 50 years ago, and I still have that class ring. The point is, the youngster that found that class ring had good title to it because he had found it. But he decided he wanted to try to find the true owner, which was me, and they did, and they sent the ring back. If the ring had had no identifying information on it, they probably would never have been able to identify me as the owner, and as a result, he would have had good title to that ring, which is made out of gold, and he would have had a valuable little piece of jewelry that he could claim ownership of. The second point of law that's interesting here is that the master of the apprentice in the goldsmith shop was liable for what his apprentice had done. And that's another subject that we might at some point in a future video look at and discuss. The term is called respondeat superior, and the bottom line is that the master is responsible for the acts of his apprentice, and that is actually more generalized than that, but in this context, that's what the court found. So they were able to sue the master for what the apprentice had done. And then there's the question of the value of the jewel, and it's interesting, this old language here, a jewel of the finest water, didn't have anything to do with water, but that's the way they used to refer to the value of jewels. And so since they couldn't produce the jewel that they had stolen from the boy that had found it, the court told the jury that what they should do is presume that it was of the finest quality possible as they made their determination of its value and what the master would owe the boy that had been cheated out of what he had found. A couple of questions, and then we'll call it quits on this video. What if, for example, they had found a puppy? Would this rule apply? That's a good question. If you knew who the puppy belonged to, the rule would apply in that the true owner could be identified, and the true owner would have better title to the puppy than the finder would. But if I found a puppy and I couldn't identify the true owner, I believe this case clearly holds that I own that puppy. How about a lamb? It'd be difficult to identify the owner of a lamb unless it was just my neighbor and he knew how many lambs he had, and one wandered onto my property and or wandered out into the street. I happened to come across it. That would be pretty easy to determine who the owner was. But if I couldn't determine who the owner was, would the lamb be mine? Probably. How soon could I eat this lamb? That would be a pretty good question. It seems to me, based on the case law, that I would need to take enough time to try to identify the true owner before I slaughtered the lamb to enjoy it as a meal. How about other living things? What if I found a human baby? Those things have happened. People have found human babies. Babies are not the kind of thing that we can claim ownership in. Even parents don't own the babies. They have parental rights to the babies, but they don't own their babies, so to speak, in the sense of property ownership. So the interesting point here is that finders, keepers. But the second part of that saying, losers, weepers, is not a good statement of the law. The finder has better title than anyone else in the world to something that's been lost and then found by him or her, except as to the true owner, the loser. So the loser is not a weeper. If the loser is identified, then that loser has a greater title to the found property than the finder. So that's our little lesson on the law today. We'll have another one for you soon. Thanks.